further dispute and allow its development to move forward. The defendants decided to put the fence right back where it was and to quit claim deed the disputed property to the plaintiffs to resolve this dispute. For whatever reason, the plaintiffs have refused to acknowledge that the dispute is over. And we're here today on a middle anguish claim, apparently, in my opinion, wasting our money and the court's time, because it's undisputed in this case that the defendants operated in good faith, that they did have a survey that showed that the fence was on their property. In Texas law, it's very clear that you cannot recover middle anguish damages on a property damage case if the defendant was acting in good faith. So I don't think legally the evidence will allow the plaintiffs to recover middle anguish damages. But I would also point out that there's no trespass cause of action pled. The only two causes of action that are pled are the declaratory judgment to determine boundary lines and a trespass to try title. So they haven't pled a cause. Now there are factual recitations that talk about the things that Mr. Adams just talked about, but there's no cause of action for general trespass. So I don't think they even can present a claim on that today and would object to them doing so.
Mr. Adams, did you plead trespass?
We certainly pled that the defendant came on our property on these three occasions alleged and committed a trespass. And that's
did you plead a cause of action though for trespass?
I think we certainly did when we pled those three actions and pled that there was damages in the form of mental anguish. That's exactly what we've pled. I don't know that we've stated, in addition to trespass to try title, a separate column entitled trespass, but that's certainly what our damage disclosures and our
when was your most recent petition filed?
March of 2020.
I've got a copy of it. I can share a screen if that would be helpful.
Sure. Let's see.
Oh, I'm getting a message that says post.
No, go ahead. Go ahead.
Okay, can everybody see that?
Sure. Yes.
I'm just going to scroll down. So this is the factual recitations. Plaintiff's claims: A, declaratory judgment to determine proper boundary line between adjoining property owners. B, trespass to try title.
Judge, can we look at
And then
paragraph 8 under that, under page 25?
I acknowledge that the factual recitations make reference to the facts that Mr. Adams spoke to in his opening, but the fact is there is no trespass cause of action.
Mr. Adams, if you didn't plead it, you're not going to be allowed to present it. So,
Judge, can I point the court's attention to paragraph 8 on page 25, which says, because of the unlawful trespasses of the property of the plaintiffs, trespass 1, trespass 2, and trespass 3 constitute deliberate, willful, and intentional trespass. Plaintiffs are also entitled to recover mental anguish damages sustained by both plaintiffs individually by reason of an approximate cause of those 3 willful trespasses. So unless we're looking for
Mr. Adams,
something more,
you got to plead it. It's not pled. So
well, I think it's pled right there.
I'm sorry. You have to plead a cause of action. You didn't plead it as a cause of action. So court's not going to allow it. So does that mean we still need a trial, or what else needs to be presented?
I believe that resolves everything, Your Honor. There is no longer a boundary dispute. The mental anguish damages are now off the table. There's nothing else to talk about.
Judge, this issue was previously advanced by the defendant in a summary judgment motion of mootness. The court will recall that we cited a Dallas Court of Appeals case that says even though the case may become moot after filed, if it's properly filed as a declaratory judgment action previously, even after the case or allegedly has become moot, that the recovery of attorney's fees under the declaratory judgment statute is still an issue that the court must dispose of. So clearly they are incorrect in asserting that by executing a quitclaim deed 3 years after they've trespassed and created all these problems for the plaintiffs, that we no longer have any form of case. So it may be true that they could argue that the only remaining issue at this point would be the attorney's fees, but the attorney's fees.
I do kind of agree with them on that. Is that, I mean, it's.
No, so Your Honor, the issue that we pled in our motion for summary judgment, as you may recall, is that you can't recover attorney's fees in a trespass case. And you can only recover attorney's fees on a declaratory judgment action if the sole issue is the boundary line dispute. Well, obviously, the sole issue in this case is not the boundary line dispute, because Mr. Adams tried to present evidence today of general trespass facts and mental anguish damages that his clients claim to have suffered as a result of that. So under the law, there is no recovery of attorney's fees.
Mr. Slate, you can't have it both ways. Either there's a trespass claim and he can't get attorney's fees, or he doesn't have a trespass claim and then he can assert attorney's fees, or he does have a trespass claim and then he can assert attorney's fees. But you can't have it both ways.
Well, I think that he would have had to. Okay. I think factually, if he had pled the case the same way he did, it wouldn't just be a case about a property, a boundary dispute. I don't believe that the plaintiff's pleadings entitle him to attorney's fees, given A, that the boundary line dispute is moot, and B, that the boundary line dispute was not the only thing pled.
Judge, I think it would be helpful for the court to hear testimony of the plaintiff's expert witness on the physical issue of whether this dispute between these parties is in fact a boundary dispute physically on the ground between these two city lots in East Dallas. That would take me maybe 5 minutes. The court would have the benefit of those opinions and the surveys and things he wrote almost from the beginning of this dispute in making any determinations of whether and how this case is in fact exclusively a boundary dispute, certainly as in light of the court's rulings that the mental anguish part of a traditional common law trespass won't be taken up today. So in order to
I just want to make it clear, Mr. Adams, I'm not bringing, you can't bring it up because it wasn't pled. It's not going to be something I'm going to allow in the future. It wasn't pled. This is the trial. So,
well, I'm just talking about the boundary dispute.
I think you're mischaracterizing what the court has done. The court has said you haven't properly pled it, so you can't assert it. It's not a situation where I'm going to put this off to some other date. Hasn't been pled. You're not going to be able to assert it. If you want to present a claim for attorney's fees, I'll allow you to provide testimony of that. But if you want to waive that, you can waive it.
We don't want to waive a claim for attorney's fees, Judge. I'm just suggesting that we have an expert witness to help
Mr.
talk
Adams,
about
would
the
you like
boundary
to make,
dispute.
would you like to assert your claim for attorney's fees or not? I'm not allowed.
I do. Yes, sir, we do.
Is the expert going to be testifying about attorney's fees?
No, he's going to be testifying about the boundary dispute nature of it, so the court can have the characterization of what he believes.
The issue of trespass, correct?
No, it won't go to the issue of trespass. It's just the physical configuration of the 439 square feet and how it's located exclusively right along the boundary. And I think that would be helpful to the court too.
Your Honor, there's no need for us to do that. We acknowledge that there was a boundary dispute initially. It's our position that was resolved by the quit claim deed. We don't need to hear testimony that there was a boundary dispute here.
If they want to stipulate that in the record, then we can avoid any need for the expert's testimony.
We acknowledge that the case was pled in part as a boundary dispute and that a boundary dispute existed until the issuance of the quit claim deed.
Is that stipulation accepted, Mr. Adams?
Yes, Your Honor.
Okay. Let's go ahead and do you want to assert your claim for attorney's fees or not, Mr. Adams?
We do.
Go ahead and call your first witness.
This time, we would urge the court to take judicial notice of the court's file to the extent the prior attorney that worked on this case has filed an affidavit that's gone unchallenged for, well, the affidavit was filed in, looks like November of 2019 by the prior attorney, Crystal Eby. And she has asserted attorney's fees and backed it up with exhibits, which are her monthly billings, stating that her time was reasonable and necessary in this case in the amount of $7,218.07. Then when I became associated on the case.
Are you I'm confused, Adam. Are you calling her as a witness? Is she here?
No, I'm tendering under Chapter 18 services, professional services affidavit. That affidavit is part of our exhibit list, and we'd ask the court to admit the affidavit of Ms. Eby, which is permissible because it was timely filed and unopposed for her portion of the attorney's fees.
We would object to the admission of the affidavit, Your Honor. The witness should be here live if they intend to offer testimony from her.
Judge, the very purpose of the statute is to avoid the need to require the professionals.
I guess what section are you relying on? I've never heard anyone make this argument that you're asserting right now. So what section are you relying on that allows you to be able to present attorney's fees in a trial without calling a witness live?
Judge, this is only a portion of our attorney's fees, and I don't have the section cited. I'll be glad to provide that to the court, but the affidavit of cost and necessity of services is not restricted to only doctors. Any professional or any other person can render an affidavit under Section 18 or Chapter 18 of the Civil Practice and Remedies Code, provided they file and follow the statutory requirements. And she's done exactly that. And that was filed or signed, her affidavit was signed October 11, 2019. And has been unchallenged for all these years for the reasonableness and necessity of her services. Her services were rendered before I was hired in the case, and I'm going to present live the balance of my services for the 3 years or almost 3 years that have passed between her withdrawal.
We would object to that evidence as hearsay.
I've never heard anyone try to use this for an attorney's fees. It's always been for medical expenses. Do you have any case law that indicates you can present an 18.0 an affidavit to prove up attorney's fees? I'm looking at.
I don't have it with me this morning, Judge, but I'll certainly be glad to provide the court with it. And with it, and I wouldn't have done it if I hadn't seen it done before. So it's you know, the court can deal with this $7,200 separate from the remainder of the attorney's fees if you'll allow me the opportunity to show you that the statute really provides for any kind of service, medical, any other service. For example, I think there's also an affidavit on file about how much it would cost to replace the fence that was destroyed, but that's now moot because the issue of removal and replacement of the fence has been taken out of the case by the settlement of the parties.
Okay, well, go ahead and call your first witness. At this point, I'm not going to admit it in. If you want to move for if you want to go and call yourself as a witness, you can.
May we call Carl Adams as an expert witness on the issue of attorney's fees in the case?
Okay, please raise your right hand. Do you swear or affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed.
Hold on a minute. I'm somehow or another knocked myself off the video. May I have the court's permission to testify in a narrative as opposed to question and answer?
Mr. Slade, any opposition to that?
No objection, Your Honor.
My name is Carl David Adams. I'm a licensed attorney in Texas. I've been licensed since October of 1975. In the early 90s, I became board certified in civil trial law, and I've been active. A significant portion of my practice has been civil litigation since 1975. I'm familiar with the nature of civil litigation and issues similar to the ones raised in this case. I have considered in reaching my expert opinions about the attorney's fees, the time and labor that I devoted, the likelihood of that I would be disqualified from accepting other similar employment, the fees customarily charged in the legal community for these types of services, the amounts involved, and the time limitations, and the other factors cited by the Supreme Court in the Arthur Anderson versus Perry case. I have provided the defendant all of the written invoices issued by my office, and there's a total of 9 of them. I provided those several months ago, and to my knowledge, I've not been asked any questions, or nothing's been raised of the notations and time in each of those, but I'll go through them for the court. My first bill was issued July 31, 2019, covering time from April 26, 2019 to July 31, 2019.
I apologize for interrupting you, but is this one of your exhibits so I could look at it while you're talking about it?
No, I'm not offering it as an exhibit. It's just materials that I provided you that I have examined to come up with my expert opinions,
Okay.
which have also been disclosed in the response to disclosure. So I've not offered them as exhibits. I don't think the court needs to have them as exhibits. You've got them if you need to cross-examine me about any of those matters. But the total time was 61.0 hours over a span of that 90 days that I just recited. In looking through those hours, I believe there's a total of 2 hours that I would have to say, in segregating my time that I charged, probably are too broad to be considered part of the declaratory judgment efforts about a boundary dispute, because they relate to matters that are no longer before the court. So the total on that bill that I believe would be reasonable and necessary would be $20,719.08. The second of the 9 bills was issued by my office on October 22nd, 2019, and it totaled 35.6 hours of my professional time. It covered time between August 1st, 2019 and October 22nd, 2019. There was similar in segregation of the time of those hours. I have identified 0.8 hours on October the 9th that I also believe would not probably qualify as attorney's fees devoted to the declaratory judgment aspect of the boundary dispute, which makes the total hours 34.8 hours, and the total money for that invoice $12,196.90. The third bill was issued by my office on December the 5th, 2019, covering my professional time for between October 23rd, 2019 and December 5th, 2019. That totaled 36.6 hours at my hourly rate of $350 per hour. No segregation, in my opinion, would be necessary for any of the hours in that bill. meaning the total recoverable attorney's fees, in my opinion, that would be reasonable and necessary, is $12,847.74. The fourth bill issued by my office was issued on January 20th, 2020, covering my professional services from December the 6th, 2019 through January 20th, 2020. Again, I've looked at the invoice and I don't think there's any of those hours. There's a total of 33.8 hours, and I don't think any of them require segregation because they're not devoted properly to the declaratory judgment aspects of the case. The 33.8 hours translates at my rate to $11,879.74. Then the fifth invoice issued by my office was issued June the 18th, 2020, covering time between February 10, 2020 and June 18, 2020. There's a total of 22 hours in that 4-month period. Again, no segregation appears to be appropriate or necessary from my review of the hours spent. And the total of that invoice is $7,758.04. The sixth bill issued by my office was issued October 21, 2020, covering the time between June 20th, 2020 and October 21, 2020. There's a total of 8.7 hours. No segregation appears to be necessary. The total of that bill that I believe is reasonable and necessary is $3,051.76. The seventh invoice was issued by my office on August 13, 2021, covering time between November 12, 2020 and August 13, 2021, a span of some 9 months. In that 9 months, I devoted 15 hours. No segregation of those hours appears to be appropriate or necessary. And the total of that invoice that I believe is reasonable and necessary is $5,256.76. The eighth invoice issued by my office was issued March 30th, 2022 for the 6-month period between September 20th, 2021 and March 30th, 2022. That reflects a total of 25.8 hours. No segregation appears necessary or appropriate, rendering a balance on that invoice that's reasonable and necessary of $9,082.54. Then the final bill that's been issued was issued July 25th, 2022, covering the 4-month span between April the 1st of 2022 and July 25th of 2022, rendering a total of 28 hours. No segregation appears to be necessary or appropriate. The totality of those 9 invoices, which recover 3 years and 3 months worth of professional time and efforts in my office, is $85,606.06. Since the July 25th, 2022 invoice, I have devoted a total of another 2.2 hours on September 22nd, attending the pretrial conference called by the court about the timing and scheduling, preparing the file and attending those. And I've also devoted that was also included in the pretrial study of leading up to the pretrial conference. Then on the 28th of September, I devoted an additional 2 hours to preparation for the trial today and attending the trial today. The total of unbilled hours in my office since the July 25th invoice is therefore 3 hours, and at 3:50 that would render a balance unyet billed of $1,050. So I believe the total through today's hearing, of my reasonable and necessary attorney's fees, in my opinion, would be $92,188.26. I believe that would be reasonable and necessary for the attorney's fees rendered to the plaintiffs and to defend themselves and defeat the boundary dispute raised by the claims of the defendant that the defendant themselves abandoned for want of merit. On the appeal, should there be one, to the Dallas Court of Appeals, I would estimate, based upon my experience in handling such appeals, approximately 100 hours would be necessary to review the record, prepare the brief, make the oral arguments, do all those things the Court of Appeals would likely expect. That would render a reasonable and necessary fee, in my opinion, of $35,000 through the Court of Appeals in this case. Thereafter, should either party file a petition for review in the Texas Supreme Court, I believe an additional $15,000 would be reasonable and necessary. That translates to 42.8 hours at my rates. If the petition is granted, an oral argument is required, I believe an additional $15,000 in the Texas Supreme Court would be reasonable and necessary, in my opinion, based upon my expectations of the time and energy that would be required to defend the plaintiffs and their position in this case, should it reach the oral argument stage in the Texas Supreme Court.
Okay, any cross, Mr. Slates?
Just a few things. Mr. Adams, the couple of, or maybe there were a few entries that you segregated out from the early bills. Can you call my attention to those again?
Yes, sir. On the invoice of July 31, 2019, which was the first one issued by my office, there are two entries, each for 1 hour each. The first being June 24th of 2019, and the second being on July 26th of 2019. And even reading those entries with as liberal a interpretation as a plaintiff's lawyer can allow, I just don't think I could make in good faith the argument that that time, as characterized on the bill, ought to be remain unsegregated from the part of the case dealing with the declaratory judgment issues. I can't remember off the top of my head what those entries said, but I did segregate them out and back them out, if you will, from any time that I was calculating in the attorney's fees. Likewise, on the bill of October.
I apologize for interrupting you, Mr. Adams. I was able to find the invoices that you sent over, and I've got them here. I'm going to go ahead and share my screen again. So if I understood you correctly, it was the first example was the July 31st, 2019 bill. Is that correct?
That's correct.
And the entries were on the 24th and the 26th.
24th of June and 26th of July.
Let me see if I can figure out. Okay, so it looks like, assuming these are sequential, this would be the 26th of July. No, it's not an hour. There's you said they were both 1 hour entries. There's an entry on the 26th for 1 hour.
Yes, let me see if I can get to that invoice as well. June 26th. Excuse me, June 24th. There's one for 1 hour, and then there's one for 0.3 hours. And the one that I think is the one I'm talking about is the one that's 1.0 hours. It's talking about additional legal research regarding adverse possession statutes and the type of proof necessary to establish adverse possession. I don't know that would qualify under the boundary dispute, because I don't think that was directly related to the boundary dispute. So I backed it out. And on the 26th of July, let's see. The 26th of July appears on page 5 of that July 31 invoice. And it looks like I devoted an hour of research to the study of the various leases of the tenants. There was a time when the plaintiffs no longer resided at this location as their homestead and leased out the 4 quote apartments, if you will. And I had them gather up the leases of those tenants because they were entitled under the statute of limitations laws to tack that possession by their tenants as their own possession. I'm sure you're familiar with that. And that clearly is stuff that would be a statute of limitations title. And certainly now, in light of a quitclaim deed, questionably ought to be segregated out from the ordinary boundary dispute issues.
Do you recall the motion for summary judgment that was heard in this case?
Actually, I think there's 2 of them, but
my apologies. The first motion.
I'm not sure. My memory wants to say that there was a partial summary judgment motion that the plaintiffs filed, arguing that their possession, adverse possession, especially if you included the tenants of the plaintiffs, and tacked that with the occupation by the plaintiffs themselves, should entitle them to say they owned the 439 square feet within the original fencing that had been in place for almost 100 years in the lot, I think it's lot 12, that the plaintiffs had occupied.
So you would agree with me that the first motion for summary judgment that was presented by the plaintiffs dealt with adverse possession issues?
It attempted to secure an adverse possession title, and the defendants disputed the facts because it involved some subjective intentions of the plaintiffs, and the court agreed and postponed that until time of trial. And all those issues have now been mooted by the defendant's quitclaim of the disputed property it originally claimed.
You didn't segregate the time to prepare the pleadings, prepare for the hearing, or argue the hearing on the motion for summary judgment on adverse possession, did you?
I did not, because at the time those were all within the pleadings relative to the 439 square feet that led up to the boundary dispute being something that should be decided in declaratory judgment in our favor. But some of this early research about adverse possession and so forth seemed like to me it was too far off the path in general research, and should be segregated out.
Well, if you've acknowledged that adverse possession research should be segregated out, then why shouldn't adverse possession motions for summary judgment and hearings also be segregated out? And in fact, wasn't a big part of your client's deposition about the adverse possession issue.
I don't recall how much of my client's deposition. I know some of it was devoted by you to questioning him about his subjective intent and whether that would qualify as an adverse possession title claimant, or to establish a adverse possession title. I'm sorry.
Just to be clear, you've segregated some adverse possession related legal work, but not all adverse possession related legal work. Is that correct?
I think that's a fair statement of it.
No further questions. Well, let me ask you one more question. Do you know how much attorney's fees you incurred after November of 2021 when the quitclaim deed was filed?
I haven't segregated them out, but the invoices I provided you would allow us to do that. I think it's responsive for me to answer the question this way. After the quitclaim deed was delivered to my office, there was an effort by the defendant to claim that made all issues in the case moot. And to defend that, we prepared a response, which I think the court sustained because the court denied the summary judgment on mootness. But other than that, most of the other time by your office and mine, I would suspect was devoted to the case coming up and not being reached or not being ready to be presented. A large portion of that dealt with the trespass and the creation of improvements on the property that has now been, as of November of last year, deeded by the defendant to the plaintiffs. And that issue was turning out to be very thorny because during COVID, finding experts that could slice the bread that thin to describe those issues and why they would reduce the market value of the property. At the suggestion of the court, you and I agreed to settle that issue by the defendant moving the fence and then the improvements. And I understand here in the last couple of weeks, that issue's been satisfied and is no longer in the trial today because the parties settled that. So, but at the time, those issues were still traveling with us, and I needed to ask the court to continue the case for that purpose.
Would you concede that in order to recover attorney's fees on a declaratory judgment action, you have to prevail in the declaratory judgment action?
Actually, my expert opinion would be that the statute itself has been construed to allow whatever the court thinks is reasonable and just and fair, and even the prevailing party, I think, under the declaratory judgment statute, can be awarded attorney's fees. So I can't agree with you on that.
No further questions, Your Honor.
Mr. Adams, do you have any other attorneys, any other witnesses to testify on attorney's fees?
No, Your Honor, other than we would again tender to the court in the form of asking the court to take judicial notice of the Chapter 18 affidavit of lawyer Eby, and I'd like the court to allow me sometime, a short matter, maybe a day or so, to submit to you the case law, if provided I can find any. I'm not telling the court I've found it already, that would allow a Chapter 18 affidavit for legal fees, provided it's unchallenged and is timely filed in advance of trial. So I'd ask the court to remind the court that we'd like that included. And if the court will give me that time, I'd appreciate it. I think I can.
We need to get this case over with. I usually would grant additional times for briefing, but we need to get this case over with. So go ahead and make your closing argument. You have 3 minutes.
Judge, on behalf of these plaintiffs, they were in peaceful possession and had been for several decades of Lot 12 in this edition in East Dallas, when the construction foreman came to them and left a note on their front door of their house saying the fence line on the north side of your property is 4 feet inside the boundary that we believe exists between the two lots. And since then, the plaintiffs have been required to defend their own title and the boundary at the boundary dispute. And ultimately, that boundary dispute was resolved, at least by the admission of the defendant, in a quitclaim deed that the 439 square feet, the whopping total of 439 square feet that led to this boundary dispute, tearing down fences, building improvements on the wrong side of the boundary, and all of the expenses for attorneys and surveyors and other intrusions in this case. So I believe that the court should grant the declaratory judgment relief that the plaintiffs owned the entire time and certainly own now after the quitclaim deed, all of lot 12 as originally physically constituted and established by the fence the defendant destroyed and tore down as part of their business efforts. So we believe the court should grant the declaratory judgment relief the plaintiffs assert and declare that the boundary as originally placed is the boundary today, especially because the defendants in their quitclaim deed have used the very meets and bounds description that the plaintiff's experts provided them, which established that same boundary. So both in speech and in conduct, the defendants have admitted that they were in the wrong when they initiated this hostile campaign. And we believe that what would be at least fair and just to the plaintiffs would be allow the plaintiffs to recover the attorney's fees, which I just went through, that are incurred in my office and will be incurred at the Court of Appeals and at the various levels of other appeal, should appeals come along. The totals in my office and in lawyer Eby's office should be included in the trial court's judgment. And we believe to do less than that would operate to reach a result that the court, I hope, would agree with us, would be unfair and unjust to the innocent plaintiffs who were minding their own business on their own property when the defendant took these hostilities. That's all our arguments.
Okay, response.
Thank you, Your Honor. Let me be clear. We never acknowledged or admitted that we were in the wrong. We had a survey that showed that that fence was on the defendant's property. We acted in good faith on the basis of that survey and removing the fence. But let's talk about what the plaintiffs have at this point. The plaintiffs have gotten exactly what they asked for in terms of we deeded the disputed land to them. We're not acknowledging our survey was wrong. That wasn't done as an admission of wrongdoing. That was done as a practical matter to resolve this dispute and to move the project along. We built them a new fence, a better fence, so they benefited from that. When the pavers at the bottom of that fence extended a few inches onto their property, we went to the cost and expense of moving them back to put them in line with the fence. And in fact, although obviously we didn't present evidence today, the evidence would have shown that the value of the plaintiff's property has more than doubled since the construction of the property next door. So to significantly increase the value of the plaintiff's property based on the defendant's improvements in this neighborhood. The only thing I believe that would be unfair and unjust under these circumstances would be for the court to award attorney's fees to the plaintiffs.
So, Mr. Slate, let me ask this. There was many opportunities to try to get this resolved prior to this settlement. I do think the attorney's fees are pretty excessive in terms of, given the nature of this dispute, I can't imagine the value of this land is that high. And so is your position I should either award no attorney's fees or all of the attorney's fees, or is there some middle ground that you would advocate?
Well, I think our initial position,
alternate grounds. Yeah,
I think our initial position would be that you shouldn't award any attorney's fees. But to the extent that you intend to award any attorney's fees, I think that they should be nominal in sum based on the amount of the value of the property, the increased value of their property as a whole as a result of this development, and the fact of the case as in terms of how it proceeded and how it resolved.
May I be heard, Your Honor, on that?
Let me ask Mr. Slade. So how much in attorney fees? I guess my thought is what should be awarded is the amount that was necessary to get to the point where the quitclaim deed occurred. And this could have been resolved a lot quicker by your client if they had not forced the litigation to go forward to this point. And so that's, I guess, what my question is what is a reasonable amount in your opinion?
Well, here's the
based
problem.
on the evidence.
Yeah, here's the problem, Judge. As you know, it's the plaintiff's responsibility to segregate. And what Mr. Adams did is segregated some things inconsistently. You know, on adverse possession, for example, he segregated some adverse possession, but not others. And so I can't quantify what is a reasonable number because the plaintiffs have failed.
Haven't you gone through the bills to make a determination of what should have been segregated?
No,
how much of the bills were for the adverse? I agree with you. It doesn't make sense to me either why some of the adverse possession bills were segregated, some weren't. I think they all should have been segregated, but how much is that?
I can't put a number on it, Your Honor. I mean, for example, when you're revising a petition, you know, how much of that is adverse possession versus trespass to title? When you're preparing for a deposition, how much of that is adverse possession versus trespass to title? So I can't give you a number. I'm sorry, Your Honor.
May I be heard, Your Honor? I think the court's original comment that the issuance of the quitclaim deed appears to be the place where the conduct of the defendant in forcing the plaintiffs to engage in the litigation and fight for the protection of their home is a logical segregation place. And if the court looks at my testimony, I think you can see the time frame. There is, other than preparation for the jury trial, which didn't go forward in March, the drawing of some reduction in the total of attorney's fees by reason of the issuance of the discovery of the quitclaim deed would make entirely proper sense. I would also make the argument that if the defendant had taken time to offer any expert testimony of the unfairness or the inequities of certain portions of the attorney's fees, then the court might have before it actual evidence upon which to reduce substantial amounts of the attorney's fees. But the defendant's attitude has been, we gave you a quitclaim deed after 3 years, and that ought to eliminate all the attorney's fees. And that's clearly unjust. So we think the court should award the overwhelming majority, if not every bit of the attorney's fees under these unique and, I've got to admit, fairly bizarre circumstances.
Your Honor, can I just make one more point?
Mr. Slade, I'm going to give you one last chance to, I'm really trying to help you and your client right here, but you seem to be not willing to cooperate. And so how much do you think would be reasonable to segregate out? Because you did ask about the adverse possession. I think that's a good argument that should be segregated out. But how much do you believe, based on the questioning and on the evidence that's been presented, should be segregated out for that? And because that's the only thing you really challenged on segregation was that one issue. And so how much is that? And then how much are the attorney's fees up to, my thought is right now is that we take the attorney's fees up to the point of the quitclaim deed, segregate out everything that's not related, and then that would be amount to be awarded. Mr. Adams is proposing to just segregate out $1,000 or $2,000, a very minimal amount. I think you had a good argument or a good question of him about why that didn't make sense, but I need a number.
Judge, I think,
And if you don't want to give me a number, I'll just go with Mr. Adams.
well, let me just make a statement, and then would it be possible for me to confer with my client briefly on this issue?
Well, why would you need to confer with your client?
Because I don't want to commit to him to pay a number that I
You're not committing. I'm just asking what your argument is on segregation. I'm not saying what do you think should be awarded. I'm asking what is your argument on segregation?
Well, okay, my argument on segregation is this. If a plaintiff fails to meet the burden to segregate, which Mr. Adams clearly has, I don't believe they can recover any attorney's fees.
I don't think that's the law, actually. And so because I've had that issue come up, I kind of agree with you. The Court of Appeals did not agree with me. And so there has to be evidence of the segregation. You did make a good argument as to the amount of adverse possession, but the Court of Appeals doesn't require perfect segregation. It's up to the court to make that determination. And so I'll ask you kind of one last time, what do you believe should be segregated out and why? And then if you don't want to tell me, I'll just go with the evidence that I have.
Your Honor, if I'm forced to put a number on it, I would say an award of $10,000 in attorney's fees would be more than they deserve at this point.
Okay, but how much, based on what? How did you, is that because his total attorney's fees are what, $100,000?
In my office, they're $92,188.26, and that's after the segregation I testified to. I think that comes to less than 5 or 6 hours, but I did take that segregated time out of that $92,188.26 for the trial court. Now, just so the court's aware, the quitclaim deed, I believe, was well after the August 2021 timeframe and didn't come until sometime during, I think it was November. Lawyer Slates might be able to correct me. Sometime in November of 2021. That's a month or two after the time that's billed in March of this year. So if you cut that 9,000 in half, that'd be a reduction of 4,500. And even if you remove the part preparing for the jury trial, it certainly wouldn't change the billing of July of 2022, which was $9,800. In my opinion, the part dealt or dealing with adverse possession at that point would be zero. So that 9813.54 there's been no segregation testimony except by me that the adverse possession part of the case was out of the case at that point. So I think
let me ask a quick question here, which is you didn't admit the billing records in this case. You didn't offer to admit that. Were those, you did ask me to take judicial notice. I don't recall of what, judicial notice of my file, I believe. Is there
that had to do with the prior attorneys?
Or the prior attorneys, okay. So the only evidence we have right now is the testimony that you've given and the cross-examination.
And I think the plaintiff's admission just in the last few moments that perhaps 4,500 or one half of the next to last exhibit could arguably still be devoted to matters dealing with adverse possession. So liberally allowing an additional offset of $4,500 from the 92,000 figure I've argued, the plaintiffs would almost stipulate at this point that that would be a rough calculation of what additional segregation if the court is asking for that, in my expert opinion, would be fair at no more than $4,500 reduction.
At this point, you're past testimony, so it's just argument.
I'm just trying to help the court go through the evidence that I presented and see how it fits the structural outline of the case.
Mr. Slates, I'm going to give you one last shot here, and if I'm not sure what else to do other than, because what the record I have is Mr. Adams' testimony. There was no contrary testimony. There are no billing records that have been admitted, and so you've argued on adverse possession. I don't see that there's any way that I can say that $10,000 is a proper segregated amount, and so if you don't want to tell me if this is like a game of hide and seek and I'm supposed to just guess, I guess I can try to do that. But it would be nice to have some argument or rational basis for what the proper segregation should be.
I have not undertaken a detailed enough analysis of those bills to do that for you at this moment in time. And I think at this stage, we're just going to have to preserve our record and make the same argument we made at summary judgment as to the inability to recover fees in this case.
Okay. So, Mr. Adams, if you take out the adverse possession, and what were your attorney's fees at that point? So anyway, I'm going to order you to take out all of the segregated amount, all of the amount that was questioned about involving adverse possession, and the attorney's fees only up to the date of the quitclaim deed. I probably would have segregated quite a bit more, but unfortunately, I haven't had any
Judge,
evidence.
if I might, I think I can.
You just go ahead and present that for a judgment. Share it with Mr. Slate. Just make sure that it says that this was heard on September 28, 2022. So I'm awarding attorney's fees and up through Mr. Adams' attorney's fees up to the date of the quitclaim deed, and segregate out the adverse possession that Mr. Adams testified, and then the additional adverse possession that was questioned by Mr. Slate, segregate that out, and then prepare judgment for me, okay?
Judge, just for the record, I didn't offer the quitclaim deed, but I'm looking at it, and the date of its execution was November the 11th, 2021. I think the defendant can stipulate that that's the date their officer signed the deed. Larry Davis, the manager for Urban Loss Bennett, and so that would be the date if the court's interested in segregating anything post that date. I'd like to understand, just for purposes of drafting the judgment, is the court also instructing me under my articulation of that an additional $4,500 would be allowed or would be segregated for time after that date, or was the court intending to allow no recovery of attorney's fees at all after that date?
No recovery attorney's fees at all after that date.
I just need to understand when I draft the judgment.
And then for appellate fees for the Dallas Court of Appeals, I think I guess there was no questioning on that. So I'm going to allow you to have the attorney's fees for the appellate fees for that were testified to.
Okay.
All right, guys, anything else?
Just to be clear, Your Honor, I made reference to the motion for summary judgment. I made reference to the deposition. I made reference to preparation of pleadings and so forth in relation to adverse possession. I assume that you're.
And any entry that includes adverse possession in it that you question about is coming out.
Okay.
So you'll need to work that out. Go ahead and submit to me this judgment. I want it by next Tuesday morning at 9 a.m. Make sure you e-file it as well as email it. make sure it says at the beginning that this trial was heard on September 28, 2022, and make it a final judgment that incorporates everything that's occurred up to this date. Also include the information about the court did not hear the trespass claim because the court did not believe it was properly pled, but did allow attorney's fees for the declaratory judgment.
Your Honor, if I may, indulge me, perhaps. I leave this afternoon for an ABA conference that goes through the weekend. Can we have a little bit more time next week since I'm going to be out of town between now and then?
I've had some issues lately with attorneys getting me judgments that are by next Tuesday. He'll prepare it. He can email it to you. Just get it to me by next Tuesday.
Okay, understood.
Thank you, guys. Anything else?
No, Your Honor.
Thank you. You have a great rest of